Yes, I hope my screen is visible now.
Yes, it is.
So we are starting with chapter 6, regulation 32 of liquidation regulation. Regulation 32 particularly provides for the sale of assets, etc. And it also provides for the modes in which a liquidator can realize the assets while in liquidation. So the modes provided here are standalone basis, slump sale, assets collectively, assets in parcel, corporate debtor as going concern, or business of the corporate debtor as going concern, provided that where an asset is subject to security interest, it shall not be sold under regulation A to F, unless the security interest therein has been relinquished to the liquidation state. In this regard, there can be a minor suggestion only that given that it is already clarified that if within 30 days, the security interest is not relinquished by the secured creditor, it shall be deemed as relinquished by them. So this particular part can be clarified here. Otherwise, I personally do not see any changes required in this particular regulation. If anyone else has anything to say on this, may please share.
Madam, suppose the security interest is on land, but building belongs to CD. Are you getting me?
Yes, sir.
So in that case, suppose land belongs to suspended director, and on the same land, the building is constructed, belongs to CD. So how liquidator should go?
So these are the concerns that you are discussing here. Particularly, so we are focusing on the changes that are required in the liquidation regulations. So the concern that you have raised is completely practical, of course, that if the land belongs to the directors and the building belongs to the company, then how the sale will happen. So in that particular part, of course, the sale will be subject to this this disclaimer that the land particularly belongs to the director and not to the company. Ideally, that should happen, and otherwise necessary direction should have been taken from shall be required from the NCLT in that regard particularly. But when it comes to this particular regulation, sir, do you think that any particular changes required here in regulation 32? So I believe that there is no suggestion from anyone. Then we are moving ahead with the next regulation, which is regulation 32A, which provides for...
Madam, Barsha madam, actually this is Rajkumar Mehto. Actually, what Mr. Ajay Jain is suggesting the difficulties being faced by us, I mean the liquidator, regarding this is one of the major issues. So nowadays, we are coming across that liquidator is advertising with a disclaimer that the land is under dispute or something that sort of.
Yes, sir.
But building cannot be sold. Building cannot be sold out. Building cannot be sold out without land.
Yes. So is the difficulty. So we need to present our difficulties before the, I mean, whosoever forum we are approaching for, because this is one of the major, invariably you will find in many cases like this.
So you are suggesting a mode or a clarification in this particular part itself, that if the land, if the asset is such that one part of the asset cannot be detached with other, and the sale is required to be made, that the particular asset that belongs to the corporate debtor, then how that particular sale can be concluded by the liquidator.
Yes.
So some clarification in this regard should be included in this particular part, right?
Yes, yes.
Right.
Yeah, Barsha, in addition to that, assets needs to be defined. So assets are very vaguely defined here.
So that you are, I believe that you are talking about the definition part of this regulation.
I'm talking about, see, when we say that assets can be sold, so which assets can be sold?
The liquidation estate it is mentioned, sir.
Yeah, it's liquidation.
The assets that pertains to liquidation estate. So I believe that clarification is required in the definition of liquidation estate itself.
Exactly.
Right, sir?
In my one of a case, there is development rights which are available to me, but those are not specifically mentioned in that regulations or anywhere defined that development rights are also can become part of liquidation estate. So we have to have a clarification on this.
Because type of assets may vary from case to case. There may be cases wherein the assets are such that cannot be detached from each other. However, the corporate debtor is holding right on one asset and not on the other. So in that particular circumstances, how that particular asset can be sold and how one can say that that asset is also forming part of liquidation estate.
Exactly.
So clarification in this particular part should be included in the definition of liquidation estate itself, so as to give comfort to the liquidator in realizing those assets.
Yes.
Right.
Since you belongs to very experienced firm, that is Kothari, he has handled many cases in CRP and liquidation. Can you suggest the clarification so that the institution can should consider the idea which you want to share?
Sir, as of now, of course, there were circumstances where we have also faced a similar situation where there were assets which cannot be detached from each other. And of course, in lack of the clarification in the regulation, we have moved ahead with the proper disclaimer with respect to the actual position of the assets. So either that discretion can be allowed to the liquidator or some clarification that may give some kind of comfort to the liquidator, that should suffice. Because giving a particular mentioning about a particular asset will not help realization in other case. In all the cases, the assets, the type of assets and the security interest therein or the type of assets belong to a particular corporate debtor, of course, varies from case to case. So the particular disclaimer, the particular insertions which are required to be made in the liquidation estate definition has to be such that will cover all types of assets and should not pertain to a particular assets only.
Can such assets be sold jointly by the CD and the landowner?
Then again, sir, that is again circumstantial. There may be a situation where the owner of the land, say suppose there may be a situation where the owner of the land is also agreeable to sell the land, such that post realization the part that will pertain to the land will be given to the landowner and the part that will pertain to the building will form part of the liquidation estate and accordingly will be distributed to the shareholders. However, there may be other circumstances as well where the landowner is not agreeable to sell the land. Here in your case, the land pertains to the directors of the company only. However, there may be a circumstances where the land pertains to other persons, those who are not directors of the company, but the promoters of the company or some way the holding company or related party of the corporate debtor basically. So there may be, the case, the particular situation varies from case to case.
So if they are not willing to sell, then there is no sale, then they deadlock.
If they are not willing to sell, then of course with proper disclaimer that the coming party has to have the proper conversation with the landowner that today I am the holder of the land, I am the holder of the building, I am passing you the building, what I am selling is the building and not the right on the land, because the land must be on lease or some kind of agreement must have been entered while construction of that building on that particular land. So what exactly is happening that in that preliminary agreement, the main party is getting substituted with the new party, the acquirer party.
Madam, what happened
the meeting is getting
director
digressed.
purchased the land? When director purchased the land for running the company, he has not anticipated that the company will go into CRP or liquidation. So he has used the fund of the CD for construction of the building. He has purchased the land from his own fund. So in that case, he might be not, there should not be any agreement or construction agreement between the director and lease agreement is also not there. If there is a lease, then there is no issue, because lease is a certain period. After the expiry of the lease, CD is not the owner of the building itself.
But till the time the building is there, the landowner also will not be able to use the land, because the landowner cannot be able to dispose of that building.
Correct.
Because the landowner do not have any right on the building. So of course, it is also acting as a restriction on the landowner as well. So there has to have some agreement between the landowner and the building acquirer. Or one can say that the building, if the landowner, not in this particular case, because not in your case, of course, the landowner is not eligible to become the acquirer, or else there may be a situation where the landowner himself will be agreeable to become an acquirer to acquire the particular building. That if land belongs to me, let the building also belongs to me only. I'm ready to purchase the building because the building is situated in my land only. So this is completely circumstantial, sir, and depends upon the case, varies from case to case.
Madam, shall we move to the purpose of the meeting? Like, now I have a question. Of suggestion. 12A is available for withdrawal of petition under the CIRP. The similar thing is not available in liquidation. So if the COC, there the COC agrees with 90%, here if the consultation committee agrees with 90% or something like that, there has to be some provision to hand it over the company to the stakeholders, to the promoters of the company, if consultation committee agrees. Such provision is not there. Can we suggest that something, to the IBBI to change the regulation and the code in this regard?
So you are talking about the onerous property, or what kind of property? That
No,
entire
property.
I'm required to sell back to the promoters only and not to others.
No, not selling back, madam. Here the 12A, section 12A is there, which will give, that, a CIRP can be closed with the approval of 90% voting of the COC. The similar provision is not there during liquidation. The liquidation also similar provision is warranted. If they settle the case, if they settle their dues, it has to be handed over to the promoters. Such provision is not extended to liquidation.
The existing promoters of the company only?
Yes.
Because in this liquidation process, sir, the company is ultimately going to be liquidated. The company is not going to continue. So the time of revival of the company was till resolution only. And therefore, when the resolution plan is being accepted, then there may be circumstances where you are handing back the company to the promoters only. But liquidation is the process of killing the company. So here you are killing the company. How can you
it is not killing the company. It is not killing the company. You can sell the company as a going concern. You can sell the
going concern is
that is allowed. So you are not killing the company. You are transferring to. It allows you to transfer it to someone else. Similarly, section 12A can be extended to liquidation regulation also. If consultation committee agrees, that can be handed over back to the erstwhile directors of the erstwhile promoters of the company, so they can run the company. If they settle all the claims or whatever the dues, or if they satisfy the applicants' requirements, something need to be done. We have to contemplate over it, because it's not
what is the reason behind this proposal? What exactly is reason behind that you are proposing this particular part in the liquidation?
Madam, what is the purpose of 12A?
Sorry,
same way. What is the purpose of 12A, section 12A?
No. In the liquidation regulation, particularly, you are highlighting that this part should be there in the liquidation regulation. So, is there any practical thing that you may have come across with because of which you are proposing this particular part?
Yes. The new promoters now they have money, they have pumped in some money, and they want to settle the whatever the applicants use and whatever whoever made the application for CIRP. Now they are quite capable to take the company back into their hands and run the company. They don't want that, let it go to liquidation. And ultimately it will be dissolved. That they don't want to do it. Hello?
Yes, sir.
Yeah. So there's some disturbance. So now that the promoters are ready to pump in money and they want to settle the issues of the applicant who has made application for CIRP, and there's no such provision either in the code or in the law, because liquidation is not a point of no return. Dissolution is a point of no return. There has to be a point of return even during the time of liquidation. That those provisions are not there even in law or in our regulation. That can be suggested, madam?
Right, sir. Right, sir.
Okay.
You are talking about insertion of something similar to that of section 12A of code.
Correct. To be extended to liquidation regulation also, but for companies which are undergoing liquidation.
Just a second, sir. So this section 12A particularly pertains to withdrawal of application admitted under section 7, 9, 10.
Mm.
So you are saying that while withdrawal is permissible specifically at the time of resolution, however, this is not specifically permissible at the time of liquidation.
Perfect. Yeah. Yes, it is not there.
So that clarification should be there. While I completely agree with you, because here it is specifically mentioned that this is required from the consent of COC members. Now, sir, again, the concerns may arise that because in the CIRP process, the total window of 180 days has been given for completion of the CIRP process. If a particular company or if the committee of creditors cannot decide whether to liquidate the company or to withdraw the application filed under section 7, 9 or 10, then what will transfer the creditors of the company to withdraw the application when the company goes into liquidation?
The time and space changes. There may be change in the business dynamics, and a lot of change could take place. It's a subsequent period, and perhaps that directors may be ready with funds to settle the dues, because the company will be safe in the hands of the erstwhile promoters than the new incumbent. So thing is, that provision is not there. If they want to do something, our hands are tightened.
So
the
this
liquidation itself will become point of no return. That should not be there, no, madam.
So this particular change, I believe, may be introduced in the code itself, because the section 12A pertains to the code. So some clarification may be inserted in the code itself, just like as section 12A has been introduced. And so as to provide a clarification in this regard, that if at all during liquidation as well, is there any window available to the creditors to withdraw the application on it?
Yes.
Right. Yeah. So moving ahead with the next regulation.
Madam, yeah.
Yes.
Madam, good afternoon. One small clarification. Madam, when the land is actually leasehold property, mostly the SIPCOT property, industrial estate. So SIPCOT properties and all, it's a leasehold property, and buildings are built by the corporate debtor. So in this case, when the assets are successfully sold out, lease has to be entered, fresh lease with the buyer, purchaser, to be entered by the SIPCOT only for the land. And as far as the buildings are concerned, it is actually belong to the corporate debtor. But is there any particular document like sale deed or something only for buildings should be executed, or the sale certificate issued by the liquidator itself is sufficient? That clarification is required, ma'am.
Ideally, it has been seen that the cases that till now, the cases that has happened, that liquidator usually issue a sale certificate wherein all the terms and conditions relating to the sale are included in the sale certificate itself. However, there is no restriction, there is no bar on the liquidator to enter separately an agreement with the buyer as well, so as to give more clarity with respect to the assets that are being sold to the buyer. So of course, the buyer may enter into that agreement as well. However, we'll see that part as to what the clarification may be included in the Schedule 1 part, because Schedule 1 particularly deals with the documentation part. So we'll see the required changes while we'll discuss the Schedule 1 part, right, ma'am?
Yes, because registration of sale deed and lease deed can be done. But sale deed and lease deed only for land, not for buildings alone. That is not practically possible. So that place lacks clarity.
Right, ma'am. So let us move ahead with the next regulation, which is regulation 32A, which provides for sale of the corporate debtor as going concern.
Your voice is still not good.
Is it clear, sir? Is it
okay. It's better
right.
now.
Right, sir. So regulation 32A, which provides for sale of corporate debtor as going concern, Of course, there are very few companies that has till now successfully completed the going concern process. There are several concerns with respect to going concern, particularly because the tax implication in the law that provides exemption from the taxation implication, Income Tax Act, particularly deals about the resolution process and not the liquidation process. So mostly when the corporate debtor is being sold as a going concern, the prospective buyer or the acquirer faces issue while handled or while taking over the control of the particular assets. And also it has been seen that the successful buyer is required to make a separate application with the NCLT so as to get relief with respect to the acquired assets, such that, you know, the electricity's reconnection or the registration of the land which were previously owned by the corporate debtor, and several concerned issue, you know, re-registration of the license, transfer of licenses, transfer of registrations which were in the name of the corporate debtor earlier, in the name of the prospective acquirer. So successful bidder is facing several issues when it comes to sale of the assets, sale of the corporate debtor as going concern. And of course, one of the major concern that arises when it comes to going concern sale is the taxation implication, because as I said, income tax provision currently provides for the reliefs, particularly with respect to resolution plan only, and there is no clarification with respect to liquidation. Whereas what resolution plan is during CIRP process, similarly, the going concern process during liquidation is available. So similar relief should also be included in the Income Tax Act with respect to this going concern sale. However, as regards the procedure to be followed during in terms of the liquidation regulation, I'll invite comment from the participants here as to what changes they think that the regulation requires.
I think the same changes as if it was a resolution. When it is sold as a going concern, it should be construed as if having the same privileges as if like a resolution. That's what is required. Otherwise, the very purpose of this is lost.
Because of course, here as well, discretion has been given to committee of creditors to identify the assets and liabilities that can be sold as a going concern. While in liquidation, there should be a sole discretion of the liquidator to identify the assets and liabilities to be sold as a going concern. So if anyone feels that particular part should be inserted or that clarity should be provided, one may please comment on that. Again, there is one insertion in the liquidation regulation which now requires the liquidator to sell the corporate debtor, to make endeavors to sell the corporate debtor as going concern only in the first auction. So I personally believe that this somehow is restricting the liquidator to optimize the sale or to get the maximum value of sale, given that this is this particular chance of restricting the liquidator to only first auction is somehow limiting the requirement of the liquidator, or there may be prospect in the liquidator at a later part as well to sell the corporate debtor as going concern. So this particular restriction which is there in regulation 4 of regulation 32A may be removed.
Yeah, I fully agree with you. This is restricted because it cannot happen. It may not always happen. Okay. And it is restricting the freedom of the liquidator. I fully agree. Endorse your views, Barsha.
Right. Coming to the next part, which is about conduct of the meeting of consultation committee. So here it says that the same process as one uses during CIRP process shall mutandis apply in case of consultation committee as well, which I personally believe is completely fine, because there should be a procedure that one should follow while calling the meeting of consultation committee during liquidation as well, given that CIRP process, CIRP regulation in detail provides the mode in which the notice should be sent, how and what gap the notice should be sent, in what manner notice should be sent. So there should be some similar kind of conduct to be followed by liquidator should be provided in liquidation regulation as well. So this is in line with the requirement of law. However, if anyone else has any comment on this, may please let me.
And the consultative committee, should it be as exactly similar to the other one? It should be like, should it be like that? Should it be more liberal compared to the other one?
So that constitution of committee has already been dealt with in regulation 31A, which
Okay,
now
fair enough.
particularly requires as to how the constitution should be there.
Okay,
Here the
that's of
regulation
course.
is not about the constitution of the committee. Here the regulation particularly
Yeah,
says the
conduct.
conduct of the meeting, how
Yeah.
the meeting should be conducted, like the quorum of the meeting, the manner of voting of the meeting, the time gap of sending the notice of the meeting, the manner in which the notice should be sent. So these clarifications with respect to conduct of the meeting of consultation committee and then circulation of minutes of the meetings. So those parts should be there in the liquidation regulation as well. So as to give light to the liquidator as to what path or what procedure to be followed. And that should not be discretionary on the liquidator that this I'm sending a shorter notice to call a meeting, or I'm not sending any notice to call a meeting, or I'm not circulating the minutes. So those should not be there. Therefore, proper conduct has to be prescribed, and therefore this regulation is required and is in line with the requirement only.
Barsha, I don't have first-hand experience, but my only apprehension is, will it be restraining on the freedom of the liquidator? Somebody who has experience can. Otherwise, okay, fair enough. I only have an apprehension. Will it restrain the freedom of the liquidator? Because after all the efforts under the IBC, COC, everything is over, the thing goes for liquidation. So then it is left to the liquidator. Okay, we have put consultation committee, but again, putting regulations, it's something which will impact his freedom. That's my apprehension.
So while I'm not able to comment on others' experience. However, given that we also have certain experience on holding the meeting of consultation committee during liquidation process as well. So we also have faced concerns or issues while holding the meeting, because this regulation was introduced at the later part and not at the beginning of the introduction of IBBI provisions. So of course, as to what and in what manner the notices are required to be issued, in what manner the minutes should be circulated, to whom the minutes should be circulated, etc. Those clarifications were required. And I believe that in terms of requirement of those requirement only, this particular regulation was inserted in liquidation regulations only. So this is
madam,
certainly
up till now, like we have been following the procedures as it is applicable to CIRP.
right. So they are just saying that the same procedure will be followed during liquidation process as well.
Okay.
Now coming to the next regulation, which is about mode of sale. This says that liquidator shall ordinarily sell the assets of the corporator through an auction, and the manner of auction is provided in Schedule 1, which we'll discuss while discussing the later part of this particular regulation, which is Schedule 1. The next says that the liquidator may sell the assets of the corporator by means of a private sale as well, when the asset is perishable, the asset is likely to deteriorate the value of in value significantly if not sold immediately. The asset is sold at a price higher than the reserve price of a failed auction, or the prior permission of adjudicating authority has been obtained for such sale. So here it has been seen in certain circumstances that liquidator files an application with the NCLT in order to get approval of the NCLT to sell a particular asset in a private sale manner. However, the application took such long time that the liquidator loses that particular buyer in the sale. Because of course, NCLT is clogged with so many applications that matters taking time to be concluded before the NCLT. And at a later part, it has also been seen that ultimately NCLT says that why you are coming to me when you have the discretion to sell the assets. So why don't you go ahead and move ahead with the selling of the liquidation estate or the assets of the corporator in the manner you want to. So there may be discretion may be given to the liquidator here to realize the assets in consultation with the consultation committee, of course, so as to save time and value maximization rather than obtaining specific approval of the adjudicating authority for doing so. Because the terms and the discretion with respect to terms and condition of sale, etc., has already been given to the liquidator, which the liquidator is required to form in consultation with the stakeholder consultation committee. So this particular discretion should also be given to the liquidator. This is what my view is. However, I'll invite the views of others as to what they think about this particular regulation, or if they think that there is particular changes required in this regulation.
Madam, here a private sale can be done to the neutral party, any willing prospective purchaser. In one of my matters, corporate guarantor has settled the OTS outside the liquidation, and he becomes he get into the shoes of the corporate debtor himself. He is actually a guarantor. But in IBC proceedings, the normal contract guaranteeship will not work out because they are related parties, isn't it? So there is certain judgments also their rulings are also there that the corporate, I mean normal contract law, contract act provisions with respect to guaranteeship will not be applicable for IBC. So such kind of rulings should be made part of the regulation itself. It should be made as a provision itself, so that it will be very clear. Even if we are not aware about the rulings, we can read the regulation and go ahead. So
While
here
you have mentioned regarding the Contract Act, we will discuss that part in the Schedule 1 as well. However, it has also been seen that even after being successful acquirer, the particular acquirer has taken the step back from going ahead with the conclusion of the sale. And there the liquidator has taken shelter of Contract Act as the very sale document which was entered between the liquidator and the successful bidder should be construed as a contract between them, and the provisions of Contract Act should be applicable thereon. So there are certain cases where these kind of covenants have been taken by the liquidator. However, we'll discuss that part in the later section of this webinar. Coming to the discretion of liquidator or the requirement of taking permission of the adjudicating authority, this particular requirement has already been given in the regulation itself, that the liquidator shall not sell the assets without permission of the adjudicating authority by way of private sale to related party or to of the corporate debtor, or to his related party, or to any professional appointed by him. So as far as the assets are being sold to any related parties or the professionals appointed by the liquidator, the restrictions can be there that that particular sale can be concluded with the prior permission of the adjudicating authority. However, in general, otherwise, there should not be any particular requirement of taking approval of the adjudicating authority in moving ahead with the sale of the assets in the manner the liquidator want to. The next provision also says that the liquidator shall not proceed with the sale of the assets if he has the reason to believe that there is any collusion between the buyer or the corporate debtors related party, which again I believe is covered in the proviso part itself, that if at all there is any such thing, then prior permission of adjudicating authority is required. And of course, while making application before the adjudicating authority, the liquidator has to substantiate as to on why and on what basis the liquidator is requiring, the liquidator is proposing for selling the assets of the corporate debtor to that related party. So this some or the other way is covered in the proviso itself. Now coming to the next part, which is about asset memorandum. It says that for cases under sub-regulation 35(1), the liquidator shall within 30 days from the liquidation commencement date prepare an asset memorandum in accordance with the regulation based on the information memorandum prepared under section 29. So it says that the way the information memorandum was prepared, in the very same manner, the asset memorandum should also be prepared by the liquidator, and the timeline is given the 30 days, wherein the cases fall within the provision of section 35(1). However, when the cases are not covered in 35(1) but 35(2), the liquidator is required to prepare the asset memorandum within the period of 75 days from the liquidation commencement date. So before commenting on this particular part, let us see what the regulation 35 says. So here the regulation 35 is, regulation 35 says, regulation 35(1) says that where the valuation has been conducted under regulation 35 of CIRP regulations or regulation 34 of IBBI fast track resolution. As the case may be, the liquidator shall consider the average of the estimates of the value arrived under those provisions for the purpose of valuation under these regulations. So this particular regulation requires that if at all the valuation has already been concluded at the time of CIRP, then there is no fresh valuation is required at the time of liquidation. The liquidator may move ahead with the valuations that were derived during the CIRP process. Whereas this sub-regulation 2 says that in cases covered under, the case is not covered under sub-regulation 1, or where the liquidator is of the opinion that fresh valuation is required, then he shall, within 7 days of liquidation commencement date, appoint 2 registered valuer to determine the realizable value of the assets. So the case is such that if at all the liquidator is required to conduct a fresh valuation, in that case, the asset memorandum is required to be prepared within 75 days. Otherwise, the liquidator is required to prepare the asset memorandum within a period of 30 days only. So this is about the regulation 34.
If COC decide that we should not go for fresh valuation because it will cost more, so can they adopt this old valuation report which has been conducted during CRP?
If the COC decides.
Yes.
Why will COC decide during liquidation process?
At the time of passing resolution for liquidation, if COC decides that this proposed liquidator will not conduct this valuation and he will adopt the same valuation report which was conducted during the CRP.
Sir, I believe that during liquidation, the discretion has been given to liquidator to decide as to whether at all a fresh valuation is required or not. And this is not up to the COC to decide that whether fresh valuation is required or not. So if liquidator thinks that the CIRP or the valuation conducted during CIRP periods is sufficient enough to move ahead with the sale, then of course the liquidator can move ahead. Otherwise, if at all the liquidator thinks that no fresh valuation is required, in that case, fresh valuation should be conducted. So here, of course, the discretion should be on the liquidator. The idea behind the same is that once the company goes into liquidation, then the complete discretion should be in the hand of liquidator to decide as to how he wants to move ahead with the liquidation process.
But you know, in the general parlance, if the existing valuation is 3 years or more, we normally conduct a fresh valuation. So
right.
in this regulation, can we insert that line? See,
yes, sir. That particular line should be there, I think, in regulation 35, because this particular regulation talks about the asset memorandum as to in what time period you have to prepare the asset memorandum.
Okay,
the valuation requirement is in the next regulation. So the requirement of conducting fresh valuation or on what circumstances fresh valuation should be conducted, those may be specified in regulation 35.
See, the valuation is the old one. 2 years back, the company come into the liquidation and RP already done the valuation. Now, after 2 years, what SCC member are suggesting to go for a fresh valuation. In this case, the advocate is viewing that in case we have to go to the NCLT and we have to get the approval, then only we can go for a fresh valuation. Or liquidator can go for a fresh valuation.
Sir, regulation is very clear. Rakesh here, sir. Regulation is very clear. After 6 months, if the valuation is for 6 months old, you liquidator may go for a valuation.
Fresh valuation, yes.
I think any valuation which is more than 6 months old is no validity because the changes in the environment and the changes in the value. This is my observations, and even NCLT have approved in some of the assignments where the valuation has not been done and it is taken on the based of the past valuation.
Mr. Rakesh, agree.
Why not you have taken the
IBBI impaneled to the members on the base of that, because you cannot do valuation because it is already, you have only empowered to do valuation within stipulated time period of 7 days. So now your timeline is crossed. Now you have no power. And on the base of that, the IBBI has impaneled the honorable members, our colleagues.
Yeah, after 7 days, if you want to do it, if the time period is closed, then you have to take a NCLT approval. That is true, because you can't go to SCC committee and they will say that you do for a valuation. So in
No,
that
no,
case, you have to
SEC,
take a.
we don't want, liquidator don't want to do this, but SEC is suggesting to do so. Whether we can go for a fresh valuation, that is what.
Sir, has SEC approved it? Stakeholders, maybe if I'm allowed to reply, I'm Devang Sampath here.
Yeah, please.
If the stakeholders have approved it, that they want in the suggestions of stakeholder, take it to NCLT and take permission. If they have not approved it, see, if you don't agree with any of the stakeholder suggestion, you have to go to NCLT. So even if you don't agree, you'll have to go to NCLT. If you agree with it, 7 days have passed, you have to again go to NCLT. And why COC and this particular aspect came up in valuation appointment? Because you have to appoint in 7 days. And a liquidation plan, maybe in terms of cost, etc., have to be approved by COC in its meeting when it is approving liquidation. And the funding has to be done as per regulation 4 within 7 days, if I correctly remember. Now, if the funding is not approved, how will you appoint? And if you appoint, then you will be able to carry out the work without funding from stakeholders consultation committee. So that is why even if liquidation, if the RP is continuing as a liquidator or even if not continuing, ideal thing is to put up in the last COC meeting that valuation will be required. Whether they approve or not, we don't know. And even if they don't approve, if the liquidation cost is more than what has been approved by COC, liquidator will have to go to NCLT for those costs.
Sir, one more thing, Devang Bhai, over here that the valuation, if it is more than 6 months old, you have to go, liquidator have to go for a new valuation, because if it is a valuation value has been changed, and if whether a fund is approved by SEC or not, cost is not a matter for the liquidator at that time.
Rakeshji, we are
Whatever the
not
liquidation
agree with
cost
your
is
view.
there.
We are not, Rakeshji, we are not agree with your views. So every 6 months, we cannot go for a fresh valuation. The law is not clear in this regard. In case
Not
requirement
sir, every
arise.
valuation. I am saying where the CRP has been ended and liquidation has been started, the two process has been different, and at that time you have to go for a valuation.
Sir, I just want to add one thing. I'm Abhay Kumar. Regarding this, say, valuation, 90% of the cases when it company goes from a CIRP to the liquidation, a valuation will definitely be 6 months old. So in that case, in all the, but nowhere it is written. These are the conventions that 6 month old valuation should not be relied upon. These are the convention which bank and others are following it. So if something of that sort is written, then it becomes a better thing for the liquidator or any other process.
Because I just like to add one more part here is that the valuation that has been arrived during CIRP process may not be same when the company goes into liquidation. Because in liquidation, against the covenants, the terms and condition, and several things changes when the company is being liquidated or is gone to liquidation. So of course, there will be several changes or the several assumptions that the valuers have relied upon during conducting the valuation at the time of CIRP may changes when a company pushes into the liquidation process. So of course there may be changes. However, the idea behind is of course, given the timeline for the liquidation process to get concluded, is that if say suppose the liquidation, the CIRP process, the window is 180 days provided for completion of the CIRP process. However, there has been cases where not the entire period of 180 days is got exhausted, but before that time only the COC decides to move the company into liquidation only. In that cases, the company, the valuation was conducted very freshly, even during that 6 month period only, and there may not be a need to move ahead with a fresh valuation, because of course conducting a fresh valuation will be time consuming as well. So just to make the entire process, given the time and the timeline provided under the code, this discretion has been given to the liquidator, that if the liquidator thinks that the valuation conducted during CIRP will suffice, in that case, the liquidator may move ahead with that valuation only. Otherwise, again, the discretion has been given to the liquidator that if liquidator decides or liquidator thinks that the fresh valuation is required, then he may go ahead with the fresh valuation also. So there
I
is
just-
no particular restriction on the liquidator to move ahead with the valuation which was conducted during CIRP only. It says it has given discretion to the liquidator to decide on the
Yeah.
basis as to whether to move ahead with the fresh valuation or not.
Agreed, but
Subsequently,
I just want to add
subsequent
one more
valuation.
thing. Hello,
One
previously,
more suggestion on timelines. Maybe the earlier liquidation timelines were 2 years. Now it has been reduced to 1 year. It is ideal if the timelines are again made to 2 years. Reason being, we have to go for extension maybe we have to file for extensions regularly, which overburdens NCLT and also increases our cost. If anyone
Absolutely.
completes it early, anyone can file dissolution early. But if the earlier timelines of 2 years or so are kept, we all know the timelines are being difficult to be kept. So at least that much of burden on judiciary and our cost will reduce of filing regular extensions.
Absolutely.
yeah. So I just want
Barsaji,
to,
my question
Madam-
is not yet addressed. Barsaji, my question is not yet addressed.
Yes.
So, during the liquidation period, say after certain period, if the liquidator want to go for a fresh valuation, can he go without taking the permission of NCLT?
So the regulation does not require permission of NCLT to move ahead with fresh valuation. If you see regulation 35 sub-regulation 2, it says that if the liquidator thinks that a fresh valuation is required, the liquidator may move ahead with the fresh valuation. You may see this regulation 35 sub-regulation 2, sir.
Okay,
There
fine,
is a
fine.
sub-regulation 2 that has given the discretion to the liquidator to decide if at all a fresh valuation is required to be conducted or not. It nowhere says that a permission of NCLT is required for conducting a fresh valuation.
I
This
have,
is within 7 days. Within 7 days of liquidation, you can appoint valuers. But if you miss the timeline of 7 days, then possibly may have to seek permission of an order from or direction from Honorable NCLT.
Now again, sir, for the subsequent valuation which may be required, or if at the later part of the liquidation process, the liquidator thinks that a valuation is required to be conducted, then what steps are required to be followed is not provided particularly in the regulation. Hence, we may say that a clarification in this required should be inserted in this regulation 35(2), that the liquidator may also move ahead with the fresh valuation of the assets of the corporate debtor at a later part of liquidation process as well, if the liquidator says that valuation of a particular asset is required. So as to reduce the burden of NCLT as well, because going to NCLT for every small little things during liquidation process as well will be time consuming and will not be in line with the very requirement of the code, which is a time bound process. Because we all know that while we are making an application to NCLT, then getting the scrutiny clear and getting the matter listed before the NCLT, then getting the matter heard by the bench, orders passed by the bench, this is a completely time consuming process. So for a particular, when we are in such a time constrained process of IBC, there should not be a burden on NCLT for moving ahead with NCLT for every small little things. Because at the end, of course, at the end of the process, the liquidator is required to give the NCLT the entire report as to on what basis the assets are realized and on what basis the realized proceeds are distributed. So at the end, in any case, the liquidator is giving the entire description of the manner in which the assets are being realized. So for every small little things going to the NCLT, I don't think so will serve the purpose.
Varsaji, your point is well taken. It means it is not provided in the regulations anywhere that subsequent valuation also, whether we require an NCLT approval or not. So
Yes,
it's a
sir.
discussion of the liquidator whether he want to apply for the NCLT or not. It doesn't, and if we have taken the SEC approval or he thinks that the valuations, the value has been increased or decreased, or the changing situation required the valuation need to be done, he can go ahead with the new valuation and take a new valuation in record and then do the e-voting or of the sale of the assets.
Sir, in absence of any clarification in this regard in the regulations, the liquidator are moving ahead with their discretion only. Some liquidators are, of course, are moving ahead with fresh valuation as and when they think that fresh valuation is required. In the other case, some liquidators are moving ahead with taking permission of the NCLT to move ahead with the fresh valuation, given that nothing is provided specifically in the regulation, or the regulation talks about the first valuation only, that is required to be conducted immediately after initiation of the liquidation process. So in the lack of clarity, the separate moves are taken by the separate liquidator. Here accordingly, a clarification is required to be inserted in this particular part. Coming to the next part of the regulation, which is about registered valuer appointed under sub-regulation shall independently submit the report to the liquidator, the estimates of realizable value of the assets or businesses, as the case may be, which is computed, of course, on the basis of registered valuer's rule after physical verification of the assets of the corporate debtor. So in what manner the assets will be valued by the valuers is completely dealt with in the registered valuer rules, and guidelines are also provided by ICAI. So I don't think so that there is any requirement particularly on the manner of valuation is required to be inserted here. And the next part says that average of the estimates derived by the two liquidators should be kept as a value of the assets or the business of the corporate debtor. Reserve price basically.
Madam, I have a suggestion here.
Yes, sir.
Yeah. So if you look at the valuation report, which is conducted during the CIRP process, that gives two values. One is the fair value and other is the liquidation value. Now come to the liquidation process. Here you have a regulation 32, which says that you have to sell the asset in this following manners, where as a going concern, business as a going concern, slum sale, or different kind of sales are specified. So if a mode of the sale changes, then which value has to be taken as a reserve value? There is a contention. So this third one, this one needs to have some clarity, because that registered valuer rule or international valuation standard, whatever you follow it, that doesn't specify those aspects. That which value, because one has to have a individual value for a type of sale you are doing it, but because that should correspond to the mode of sale.
I completely agree with you on this, sir, that should be provided here as to on what basis, on what particular value should be considered while deriving the average of the estimated of the values derived by the registered valuer. And also the other part, that the value established or the value derived by the liquidator should be kept as a minimum value for the asset. That should also be clarified here, because that part is also not covered here. That is a minimum value and not the value at which the asset has to be sold, or not the value at which the below which the assets can be sold. So here this clarification should also be provided, that should be the minimum value at which the asset can be put to sale by the liquidator. Now coming to the next part, which is asset sale report. It says that what all information should be provided in the asset sale report when the assets are sold by the liquidator during liquidation process. And this asset sale report forms part of the progress reports only. So this says that the asset sale report should contain realizable value, cost of realization, manner and mode of realization or manner and mode of sale, and manner and mode of sale. And if the value realized is less than the value in asset memorandum, the reason for the same. So on what basis and why the value is lower than the value that was estimatedly mentioned in the asset memorandum. As we have checked in the regulation before, regulation 34, that in the asset memorandum, the liquidator is also required to mention the estimated value of the assets, the value in which the asset may be estimatedly can be realized. So if there is any differentiation between the two, the reason thereof should also be required to be mentioned here. Next part is the person to whom the asset is made and any other details with respect to the sale. So these details are required to be mentioned in the asset sale report, which will form part of the liquid progress reports only. Then coming to the next regulation, which is realization of security interest by secured creditor. I believe that this particular regulation is of concern for everyone here, that the when it comes to security interest on the liquidation estate or on the assets of the liquidation estate, all the professionals or all the information, all the insolvency professionals might have faced the issue and difficulty. So this particular regulation, I think, requires a cursor view. So this regulation, first of all, says that the secured creditor who seeks to realize the security interest under Section 52 shall intimate the liquidator at the price in which he proposes to realize the security interest, and then he is required to inform the secured creditor within this 21 days of timeline of the receipt of intimation that if a person is willing to buy the secured assets, but before the expiry of 30 days. When the liquidator informed the secured creditor of a person willing to buy the secured asset under sub-regulation 2, secured creditor shall sell the asset to such person. If the liquidator is determining, then the secured creditor has to sell the assets to the other person only. Then the next says that liquidator does not inform the secured creditor in accordance with, if the liquidator does not inform the secured creditor in accordance with the requirement of sub-regulation 2, or the person does not buy the secured asset in accordance with sub-regulation 2, secured creditor may realize the secured asset in the manner as it deems fit, but at least at the price as intimated under sub-regulation 1. So that is a minimum price in which the asset should be sold. The next says that secured creditor shall bear the cost of identification, and the next thereafter it says that the liquidator shall bear the cost incurred to identify the buyer, if that is as per sub-regulation 4. And then it says that the provision of this regulation shall not apply if the secured creditor enforces his security interest under SARFAESI rule, which is but obvious that if I'm enforcing my security interest, in that case, there is no requirement to follow the provision of this particular regulation. And the new insertions therein was that secured creditor shall not sell or transfer an asset which is subject to security interest to any person who is not eligible under the code. So there is a restriction which specifically restricts the secured creditor to sell the assets to any ineligible person. The eligibility has to be derived in terms of sections 29A. If anyone has any comments or any suggestion here, may please let me know.
Although the insertion is okay, but I think it just infringes on the other law, I would say.
Sorry, sir. May please repeat once.
I noted that insertion, that it should not be sold to any ineligible persons. Okay, okay, I understood. Okay, it has in some good spirit, but actually it is in conflict with the other law, which is independent from the IBC.
Yes, so you are saying that it is not there in the SARFAESI or other rules, this particular restriction. So this particular restriction is conflicting with the other provisions.
Exactly, that's my point. Although it is good intention, I appreciate the good intentions.
But this particular restriction should not be there. If a secured creditor is anyway realizing outside the liquidation estate, so the particular restriction as to whom he is selling, that should not be of
exactly concern. See, under the SARFAESI, it is absolute discretion of the secured creditor to sell it to anyone, notwithstanding section 29 of IBC. It is not under IBC. He is acting under SARFAESI, which is totally a different statute.
Correct. I also agree on this with you, sir. If anyone else has any concern on this particular part, may please discuss their views. So I'll just repeat what has been proposed to be inserted here is just that the particular restriction which has been given in case of secured creditor realizing the security interest or the assets in which security interest are being held to any person who's not eligible or who is ineligible in terms of section 29A, that particular restriction should not be there, as because the secured creditor is not realizing the asset in terms of IBC, but outside the IBC. So the restriction of IBC should not be applicable on secured creditor when the secured creditor has decided to realize the asset outside the code or outside the provisions of this regulations.
Exactly.
So this particular restriction should not be there. However, the contribution part, the identification part, the expense bearing part, everything can be there But the restriction should not be there as to whom the asset should be sold.
Because it is the sole discretion of the authorized officer under SARFASI to do it. Authorized officer is a quasi-judicial officer. So it is like his discretion. Okay, not that he has to look into IBC and go in that.
Now coming to the next regulation, which is regulation 37A.
Sorry to interrupt.
Yes, sir.
Actually, my opinion is that this restriction is correct because it is the object that promoters should not try to enter into the process of CIRP or liquidation again, and by getting the benefit out of buying the properties, because secured creditors were not able to sell the property or to invoke the provisions of SARFASI, and they were not succeed to get the realization of the security. And now the promoters will come again, and then what is the use of going for liquidation? And if suppose secured creditors have come outside and have invoked section 52, and if promoter will come again into picture, then it could have been a position like OTS, and they will get the clean sheet, they will get the property back in the hands of promoter at the price which may be negotiated with the secured creditors, because on that particular purpose, liquidator has no control over the amount or realization of the assets. If liquidator would have been an independent, or section 52 would have not been invoked by the secured creditor, then maybe liquidator can get the better realization. But it would be difficult to find better realization by the liquidator out of the preview that secured creditor will go and provide the amount of the realization value, and liquidator will also try to get the maximum value or value more than what secured creditor has proposed. So therefore, I think this provision is having rational object behind the CIRP provisions, liquidation.
So our views were on the basis that if at all I have given discretion to a particular secured creditor to realize the asset outside the liquidation process or outside the process which is going on, then why at all I am restricting that particular creditor that you have to sell the assets to this person only, and you cannot sell the assets to a particular person who is even ready to give maximum value to you. Because ultimately, if I am a secured creditor and I have decided that I am having security interest on a particular asset, and I will not give my asset to the common pool, and I'll realize that asset outside the common pool. So whatever relation will be there, that relation goes to me. And if I am thinking that I'll get better value by selling the asset to this person, so why at all there should be any restriction on me to sell the assets to any other person and not to this person who's ready to give me maximum value? Because in any case, whatever value will be derived, that will go to me completely. I'm not making my asset, or I'm not contributing my asset to the common pool. So that was the only idea behind our views, sir. However, we have considered your views as well. Accordingly, we'll
in that case, then we should give free hand to the promoter for participating in the resolution plan also, because it is the only, it is promoter only who can give the better resolution plan than any other resolution applicant. And even in the case of,
in case interest of all the creditors are involved, sir.
If we go for other realization, if suppose the assets are not or security interest is relinquished by secured creditor, in that case, will you allow liquidator to sell property to the promoter also? If liquidator is not allowed to sell the property to the promoters, then why secured creditors should be allowed to sell the property to promoters back?
Sir, because liquidator is bound to follow the liquidation provisions. However, the secured creditor is not bound to follow the liquidation provisions.
So they are also equally responsible to follow the process of liquidation.
Even if
and
the
they should also
consider
themselves as to be stakeholder in the entire process. Therefore, I think this provision is good enough.
While
It is
some
my
morally,
personal
what you are
opinion.
saying is
Anyway.
absolutely correct. And on moral terms, of course, whatsoever you are saying is absolutely correct. However, on practical perspective, we thought that there may be certain, restriction on this particular part, and hence we have proposes that was a view that we had, sir. In any case, sir, your view has also been noted. So accordingly, we'll make necessary suggestions to IBBI.
Yes, yes.
Now coming to the next regulation, which is about not readily realizable assets, which was of course introduced at a later part of the liquidation regulation. This particular provision says that liquidator may assign or transfer a not readily realizable assets through a transparent process in consultation with SCC in accordance with regulation 31A for a consideration to any person who is eligible to submit a resolution plan for CIRP of the corporate debtor. Here, there is explanation as well that says that what not readily realizable assets are. So these assets, of course, include the assets which are contingent or disputed, or the assets which are underlying the proceedings of preferential, undervalued, or extortionate credit transaction or fraudulent transaction in terms of section 43 to 51 of the code, or 66 of the code. So here, while it is clarified as to what not readily realizable assets are, however, it is not clarified as to if all the liquidator is required to take permission of the NCLT before moving ahead with, or before making transfer of such kind of assets to the eligible person. Hence, it has been seen that the liquidators are mostly making applications to the NCLT to transfer or assign these kind of assets, so as to ensure the smooth transition of these kind of assets in the hand of the acquirer. So clarification may be inserted in this particular part, whether sole discretion may be given to the liquidator to transfer the assets in the favor of the acquirer as far as the eligibility certificate or the eligibility undertaking has been acquired from the particular acquirer in this particular concern. If anyone else has any suggestion on this particular part, may please discuss that. Okay, so I'm moving ahead with the next part, which is about distribution of unsold asset. This particular regulation requires the liquidator or gives the discretion to the liquidator with the permission of adjudicating authority to distribute among the stakeholders an asset which could not be sold, assigned, or transferred due to its peculiar nature. Because the ultimately distribution will be to stakeholders only. So if at all there is such asset because of which the liquidation process is stuck, or the liquidator is unable to realize the asset, or even unable to transfer or assign those assets as well, in that case, the right has been given to liquidator to take the permission of adjudicating authority before assigning those assets among the stakeholders only. Here, in what manner the distribution has to be made may be just clarified here, because it simply says that distribution amongst the stakeholder. In what manner the distribution is required to be made, that part may be clarified here in sub-regulation 1 of regulation 38. The next part says that applications seeking permission of adjudicating authority under sub-regulation 1 shall contain the identity of the asset, the value of the asset, details effort that the liquidator has given to sell the assets, and the reason for such distribution. So why at all the liquidator intends to distribute the asset rather than realizing the assets in the manner provided in regulation 32. So a mere clarification, I think, should suffice in this particular regulation. The manner of this, the idea behind is to distribute. So in what manner the distribution has to be proceeded ahead with may be included in sub-regulation 1. Now, next comes to recovery of monies dues. It says that liquidator shall endeavor to recover and realize all the assets of and dues of the corporate debtor in time-bound manner for maximization of the value of the stakeholder, which is completely in line with the very base or very requirement of IBC itself. The next is liquidator to realize uncalled capital or unpaid capital contribution, which is rarely a case seen these days, that there is any uncalled or unpaid capital contribution. So this particular provision says that the liquidator shall realize the amount from any contributory if at all there is such a situation of uncalled or unpaid contribution by any contributors. It also
but-
says that
Barsha, regulation, can I just make a word about regulation 39?
yes, sir, please.
Regulation 39 was only an advisory statement. It is not even a regulation. But it doesn't specify any rights or rights by which a liquidator can realize those monies. No, otherwise this is only an advisory thing.
So you are saying your suggestion is that the manner or the detailed manner of the discretion of the liquidator or the
Some
rights
power.
available with the liquidator may be provided herein so as to give a
some power
better
to
clarification.
equipment. See, for example, it says that XYZ has to pay some money to the CD. Okay, then how does the liquidator get that money? Endeavor is only advisory terminology. Unless you give the power to liquidator, what is the purpose of this rule?
I agree, sir. So that clarification as to what all discretion or what all power the liquidator has when it comes to recovery of money dues, that may be clarified in this particular regulation so as to give a better clarity on the powers of the liquidator when it comes to recovery of money dues of the corporate debtor.
Exactly.
Coming to the next part, which is regulation 40, which I discussed in brief before as well, that the relation of uncalled capital or unpaid capital contribution, which is rarely seen these days. So if at all there is such situation, this particular regulation gives right to the liquidator to realize those amount. And this also says that notwithstanding any charge or income grants on the uncalled capital of the corporate debtor, the liquidator shall be entitled to call and realize the uncalled capital of the corporate debtor and to collect the arrears, if any, due on the calls made prior in the liquidation by providing a notice to the contributory or to make the payment within a timeline, but a 15 days timeline has been given for the same. Then third part says that no distribution shall be made to a contributory unless that contributory has made the entire payment towards the capital contribution. So this, as I said, that this uncalled capital or unpaid capital part is rarely being seen. However, if at all there is any situation, then there will be no payment to a share to the shareholder or to the particular contributory who has made any partial contribution towards this towards the capital of the company. However, given that this is compulsory liquidation, this is a liquidation for insolvent companies, and there is the circumstances of any payment to the contributory is rare because it has not been seen. It has been seen in all the cases that has happened till date that even the payment to first line of creditor, first priority secure creditor, has not been made in full. So any question of making any payment to contributory does not arise at all. So this particular part, I'm not sure as to what is the purpose of inserting this particular part here, that there should not be any payment to the contributory. If anyone else has anything to comment on this particular part, may share their views. Okay, so I'm moving ahead with the next part, which is about money to be paid from bank account. I believe that almost all the professionals might have faced issue while opening the liquidation account with the bank, because they particularly ask for several documents while opening the bank account. The KYC documents, the order of the bench, and so resolution, etc. So many documents they require, and many. It has also been seen that many banks have even denied of giving all the facilities that are otherwise available to the other bank accounts to the liquidation account. However, which is it is most common that like other accounts as well, in the liquidation account as well, the facilities are required. Of course, I'm not discussing or I'm not referring to debit card or credit card, but I am referring to the net banking facility, which is very much required when it comes to liquidation account, because it is not possible for the liquidator all time to draw check for making any payment. As far as the record of payment is concerned, that may also be generated through the bank statement itself and can be easily seen from the bank statement itself. However, internet banking facility, there has been circumstances. There are certain banks which have completely restricted from providing internet banking facility to liquidation account. Well, we have accounts in bank and have internet banking facilities as well. However, certain banks do have this restriction that they do not provide internet banking facility or FD creation facility or term loan facility or the term deposit facility or that sweep in sweep out facility in the liquidation account. Well, as far as if I have a money in my account, if you are ready to give that sweep and sweep out facility to my other accounts, why at all this liquidation account is not being provided those facilities? So these issues are, I believe, that all the professionals might have faced when it comes to opening the liquidation account. So this regulation says that liquidator shall open a bank account in the name of corporate debtor.
Barsha ji,
Yes, sir.
can you suggest the liquidators friendly bank name? Because you have lots of experience.
So I cannot point out any particular bank name because insofar we have had account in several banks with the name of course, the respective corporate debtor, and we are facing issues with almost all the banks. So we cannot say that any particular bank.
What type of issues you are facing, Jan Sahab?
As I said, sir, in some bank, they have completely said that they do not provide internet banking facility to liquidation account.
Okay.
Then on one case,
Yes
they
Bank
said
provides
that they will
that.
No,
Ma'am, Yes Bank provides that, but again, their net banking is very cumbersome.
better to open account in Punjab and Sindh Bank. They are very friendly. I have opened 4 or 5 accounts there.
Okay,
you are
thank
promoting
you.
Punjab National Bank here.
Thanks for your suggestion.
Punjab and Sindh Bank, Punjab and Sindh Bank, and it totally depends upon your personal relationship.
So sir has suggested to open the account, and I believe that Mr. Jain, your concern has also been addressed, that in which particular bank is liquidator friendly bank. So let us move ahead.
There are so many private sector banks who will come to your doorstep and will open the liquidation account.
But sir, they also say that they have their legal team, then they will go to their legal team.
No. You
ask-
approach Axis Bank, you approach Yes Bank, they will do it. All branches are doing it. And if
Well,
you
we
need any
also have
person contact
account in
number,
Axis Bank, so
even Kotak Bank, I have got a call and all for that purpose. Axis Bank, I have already opened the account. So if anybody need the number, I'll leave at a chat box. Okay.
Right.
Thank you.
So let us move ahead. So this particular regulation requires the liquidator to open a bank account, which should followed by the word in liquidation in scheduled bank for receipt of all the monies dues to the corporate debtor. And it also says that a liquidator shall deposit in the bank account opened as per this section all the monies, including checks, demand draft received by him. So all the payment and all the receipts should be done through this account only. Here, I think one clarification is not there, that if at all liquidator has if at all say the corporate debtor has an account and the liquidator wants to convert that particular account only into the liquidation account, so that permission, I believe, may also be given in the liquidation regulation itself, because there has been circumstances that the income tax refund is pending for the company or some other due, some payments if the corporate debtor is in day-to-day receipt of money. So in that circumstances, it has been seen that the regular account of the company is required to be maintained otherwise as well. So discretion may be given here to continue with the normal account of the company, of course, by converting that account to liquidation account. So there should not be a particular
existing
requirement of
account,
opening new account only.
Existing account can be converted into liquidation
account
by
yes.
changing the title.
Yes. So
Okay.
that particular part is not a particular mention here. However, it has been seen that almost all the liquidator are following this process to convert the account into the liquidation account only. Because the regulation here specifically says that liquidator shall open a bank account. So this insertion that or may convert the account into liquidation account, that
will be better. Conversion will be better. Yes.
I have a point to make it.
Yes, sir.
Look, as a banker, I'm a banker, okay? IP, okay? So because of the regulation 41(1), you cannot convert the existing bank account because the liquidator's bank account is in the character of a trust account. See, you're holding money of somebody's asset, but the existing account was actually the old CD account. Liquidator opens the account for the purpose of the liquidation proceedings, receive the proceeding. So the KYC part, as you said, the KYC part will be a little tough, but a separate account is only that is required, and that is what is the intention of the 41. Otherwise, the intention of the 41 is that shall open a bank account. You cannot continue that, because that the earlier part of the account and the post liquidation part are totally different, and the laws relating to that is different. I understand the income tax part, but that we can represent the income tax. Otherwise,
so I'm telling you the practical difficulties that professionals are facing, sir.
Yeah.
That given that there may be circumstances that a particular corporate is not in a going concern conditions. However, there may be circumstances that when corporate are in going concern, there are agreements or assignments, and the vendors have particular this account only to make payment. Now, in order to receive, because regulation particularly requires you to receive any money in this account only, in the liquidation account only, and not to the other account. So until unless you will have the particular account open, and until unless you change the account as are in the database of all the vendors and everybody, you'll not be able to make or any payment or receive any money. So just to smoothen the process, it was a proposal to convert the existing account only to the new account, because otherwise as well there will be no need to maintain the other accounts, because in other accounts you will not be able to receive any money, you will not be able to make any payment. However, you have to maintain the other account as well. So the maintaining so many other accounts will be of no use. So it's better to have one single account wherein the liquidator will be able to receive money, the liquidator will be able to make payment as well, because changing the bank account details in the income tax portal as well is also a time consuming task. So just for the sake of providing some easiness to the process, it was proposed to change or convert the account into the liquidation account.
Barsha, there is a question from Mr. Matthew, being the ex-banker. When liquidator opens a current account of liquidation, then banks ask for the initial deposit amount, 5,000, 10,000, 25,000. So how the liquidator will manage that payment? Whether liquidator will, at the time of opening the bank account, liquidator will pay from his own pocket for opening the bank account, or that condition should be waived off for the liquidation account. Otherwise, bank will debit the bank charges for non-maintenance of minimum balance charges. Mr. Matthew, this queries is for you.
Yeah, I think that we should waive it.
We should?
Yeah, we should waive that condition of minimum balance.
But banks are portal never allowed to waive of this type of conditions.
Yes, yeah, accept. So it should be inserted here actually.
And at the time of opening of bank account, whether the liquidator is required to give his own check?
No, definitely not. That
Then
should
no,
be waived, because it
then
is
no,
then
no bank will open your account, sir.
It is a continuation of the other CD's account. Since the CD's account cannot be continued, you have to open another.
That's why I'm saying that then no bank will open the account.
No, sir. See, because the capacity of the liquidator and the other account is different. Liquidator's capacity, trustee is like trustee executor. That is the capacity of the liquidator.
That's I know. But banks people does not understand this. For them, account is account, whether it is current account or saving account.
No, because the provision has to be inserted. Otherwise, the normal account.
Yes.
Yeah, the provision has to be
inserted. Vikramji.
No, while I agree with Mr. Matthew about inserting of the provision, practically we have opened liquidation accounts with no starting balance, zero balance. I don't want to name the bank, but the bank's name was already mentioned by somebody else a little while back. So, and we've opened liquidation accounts there, and we've got internet banking. It's working smoothly. And as and when contribution comes, we put in the money, but no minimum balance was required. And most of the banks now understand that these IBC processes, particularly where cases are there which are not in a running position, and then there would not be any funds.
We opened account in 2019.
Then things are different.
At that time, no bank was
22
opening the account.
Yeah, I agree. 22, 23, things have improved. Okay.
Okay, coming to the next part, I have a query. Yes, ma'am. In case of, in relation to the RBI notification, that if the company has CCOD limit of more than 5 crores, then no other current account can be opened in any bank. So even if in the CD, the CD has taken CCOD of more than 5 crores, I could not open the liquidation account in other bank. This is the problem I was difficulty that you have faced. Yes.
That's
Well,
a regulation of RBI.
Yes. But in that it should be, there is a provision that if it is, the account is to be opened in relation to any other act, then it is allowed. Means on that basis, I have opened that account, another account in another bank. In any case, IBC have the overriding effect on anything contradictory to the provisions of IBC. So I think that ground may also be taken here. Yes, but banks don't understand anything. They are very new to IBC, I think. Even if the bank is the backbone of this IBC, but the lower people don't understand anything. They even ask for the Shop Act license of the CD.
I beg to differ. Banks are the highest users of IBC.
Yes, but they are not. When you go to the bank branch, nobody entertains.
Down the line, people, because the IBC cases are dealt at the higher level. So down the line, people have less knowledge, I admit.
Yes, yes.
Because
Okay,
IBC is
so-
always big accounts. It's dealt at 2 or 3 levels above the branch.
So I believe that this particular regulation had a lot of concerns of all the professionals. So let us move ahead with the next regulation, which is regulation 42. This says about the distribution of realization proceeds, realized proceeds. Mr. Ashish Bhatta, I would request you to kindly mute yourself. So this regulation 42 says that liquidator shall not commence the distribution before the list of stakeholders and the asset memorandum has been filed with the adjudicating authority. I think this is absolutely perfect, given that when you are making distribution, so the first question comes up is to whom to distribute. So whom to distribute can be decided only when list of stakeholder is there. The second question is what to distribute. So until unless you realize you'll not be able to distribute, so there has to be asset memorandum, which will contain the details of assets that pertains to the corporate debtor, the estimated realizable value, and based on which you have realized. So those two documents should be intact, should be there before you move ahead with the distribution of realized proceeds among the stakeholders. Then it also says that liquidator shall distribute the proceeds from realization within 90 days from the receipt of the amount to the stakeholder. So as soon as you realize the amount, you are also required to distribute the amount and should not keep it on hold. The distribution should not be kept on hold. The next part is that liquidation process cost, if any, and the liquidation cost shall be deducted before the distribution is made. So this is also completely in line with section 53 itself, because the section 53 subsection 1 says that the first priority payment or the first payment should be towards the liquidation cost or CRP cost, and then to the stakeholders. So this is completely in line with the section 53. Coming to section 40, regulation 43, which is return of money.
Barsha, can liquidator distribute the fund for meeting the liquidation cost if fund is available with the liquidator before filing the distribution list or before filing the stakeholders list?
No, sir. This particular regulation completely restricts you from making any payment. So irrespective of the fact that you have the money in your account, because even if you have the money in the account, that is also forming part of liquidation state only. And you are not able, you cannot make any distribution until unless you have prepared that list of stakeholders.
For meeting the liquidation process, like Welber's fees or accountant fees.
In general cost of costs, you have to make the general cost which are required to be paid, and you cannot wait till the list of stakeholder and asset memorandums are done, because in between, the moment the process is initiated, you are also required to make payment towards the newspaper publication, because there's a timeline within which you are required to make newspaper publication. So how will you make payment towards the newspaper publication until unless you know, how will you make the newspaper publication?
If I have fund is if fund is available with me because of the some income is coming to the CD, then liquidator can distribute can incur the expenditure for meeting the liquidation cost.
So that will form part of liquidation cost only. It talks about the particular distribution, I believe.
This is absolutely ridiculous. Then this provision is absolutely ridiculous. If liquidator is not allowing to meet the day-to-day expenses, publication expenses before filing the list with the AA, then this is absolutely ridiculous, because one application take 1 month in listing in case of some defect comes, in case of certain change in the bench like that. So it will derail for 1 month, 2 months, the liquidation process.
So, Mr. Jain, I believe that you are saying that here a carve out can be given towards the liquidation cost. That
yes, absolutely, absolutely. You are just putting the cart before the horse for liquidation process.
Subject to the provision of section 53.
No, Barsha, what is there? Distribution means distribution to the stakeholders.
Stakeholders, yes.
Yes, not for the liquidation cost.
But sir, see here this regulation as well. This says that subject to the provision of 53.
Yes.
The liquidator shall not commence distribution.
Yeah, exactly.
Here it is not specifically mentioned that distribution to the stakeholders only. If we see section 53, section 53 begins with the liquidation cost only. The first part.
Yes, it starts with the liquidation cost and CRP cost.
So here maybe just one clarification may be given here.
These provisions require urgent modification.
No, here just one clarification may be inserted, that except liquidation cost and
that's what I am telling.
If that particular part is inserted, then this particular regulation is completely in line with the requirement of the book.
Yes, because
agreed.
Now coming to regulation 43, which is about return of money. So it says that stakeholder shall forthwith return all the monies received by him in distribution, which he was not entitled to at the time of distribution, or subsequently become not entitled to. This is again is a perfect requirement. Even in the distribution documents also, it has been seen practically that liquidator gives this disclaimer that what I am distributing, if at all at a later part the situation arises or the circumstances come when it will be determined that you are not entitled to the money, in that case you will be required to return that money back to the liquidation estate. Now coming to the completion of liquidation, here one clarification was inserted with to completion of the process, given that there are one mode for realization of asset is also going concern, where the corporate debtor need not be dissolved. The corporate debtor is not required to be dissolved, and the liquidation process is required to be completed. So this clarification is provided that there may be situation of completion of the process, or the liquidator may be required to be dissolved. So this particular regulation says that the liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding the pendency of any application for avoidance transaction, because this was also one of the issues faced by the liquidator as to what to do when my avoidance application is pending, because avoidance application has been seen that these applications are taking longer time than usual to be heard and to get concluded. So can I hold that liquidation process till that time?
No, see, avoidance application is a 5 years planning. One avoidance application is having Panchvarsiya Yojana.
Some or the other way you are correct only, sir, because it has been seen, that is what I'm also saying, that it has been seen that the avoidance transaction applications particularly are taking longer than usual, and one cannot hold the dissolution process till the avoidance application is getting heard. So in order to give clarity in that part only, this clarification was inserted in liquidation regulation. The next is Mr. Ajay Kumar Agarwal, I'll request you to kindly mute yourself.
Extremely sorry, ma'am. Extremely sorry.
Yes. So next part is, if the liquidator fails to liquidate the corporate debtor within 1 year, he shall make an application to the adjudicating authority to continue with the liquidation proceedings, the liquidation process, along with a report explaining why the liquidation process is not completed and specifying the additional time that shall be required for completion of the process, which I believe that all the liquidators are doing these days, are making applications seeking extension of the liquidation process, given that it is not possible in most of the cases to conclude the process within a period of 1 year as a timeline provided by IBBM. Now, the explanation is also given.
Barsha,
yes.
Barsha, in my view, there must be some suggestion for NCLT also, that after 1 year or after filing the dissolution application, within how much period they should close that application.
How much time one particular case should last. I think that some clarification should be there, because it has been seen that even if the liquidation process is complete, the connected applications are pending before the NCLT, and because of which the liquidation process is also continuing.
Yes.
For dissolution, some timeline should be inserted here.
For dissolution of the company, because avoidance application, 66 application is pending. So what the practice is going on, they did not consider unless and until that application has been ruled out.
Correctly mentioned, sir. So some timeline should be inserted here for
Some
those particular applications.
Or otherwise some marking should be there ki dissolution application shall be considered pending the other avoidance or 66 application.
No, that part is also there, sir. That part is already there in sub-regulation 1. It says that dissolution application can be considered. But
yes. But dissolution practically it's not going on now.
So practically what is required is the main CP under which the IAs are filed is not, till the time that main CP is not getting dissolved, the matter is getting stuck, and liquidator is also required to be stuck because the connected CPs are pending. So there may be some insertions to draw attention to the NCLT benches for particularly those applications in which dissolution has been done or completion process has been done. However, connected applications are pending for consideration of the bench.
Which is not possible in this regulation, because this regulation has been made for the IRP, RP or liquidator. The regulation or the provisions has to be made in the code, only code. So that the instruction should be given to the AA to dispose of the application within so and so time, irrespective of this avoidance application, other applications.
No, it can be, Jensen, it can be there also. Like a sub-regulation 1, it is there pending the avoidance applications.
No, this is delegated legislation, so it cannot be it cannot instruct to the AA to dispose of the application. It can only be made in the code, IBC.
I agree with you, Mr. Jain, because there is no provision here till now that we have seen that that is making the compulsion on the adjudicating authority to do something. So it is completely on the liquidator, and liquidator is required to even take permission of adjudicating.
Barsha, even whatever mentioned in the code also is not applicable on A.
That part, I believe the bench is also saying that what the timeline that is given is not mandatory, is not bounding on us.
That's why I'm saying, but there must be some, otherwise dissolution application is going on since last 2.5 years.
Correct, sir, correct. So next, coming to the treatment of avoidance transaction, it says that liquidator shall, on advice of the consultation committee, provide in the application along with the final report filed under regulation 45 for the manner in which proceeding in respect of avoidance transaction, if any, under chapter 3 or fraudulent or wrongful trading under chapter 6 or part 2 of the code will be pursued after dissolution. So this particular provision requires that, given that this liberty has been given to liquidator to move ahead with dissolution while avoidance applications are pending. So now liquidator is also required to mention the manner in which the avoidance transaction should be carried on after the conclusion of the liquidation process or after the dissolution of the corporate debtor. earlier, if you have seen the consultation paper provided by IBBI, there this particular requirement was on stakeholder consultation committee. Then the suggestions were given to decide the course of action for the avoidance transaction proceedings, or to take necessary calls on that regard by the stakeholder consultation committee. However, when that particular suggestion got implemented, it again came on the shoulders of liquidator to decide as to how the avoidance transaction proceedings will be taken forward. So this may be concluded in line with the consultation with the stakeholder consultation committee as to if at all any of the stakeholder consultation committee members are required to proceed ahead with the manner, because there has to be some timeline by which the liquidator should also be released from their duties. Coming to the next part, which is Regulation 45, it is about final report prior to dissolution. Says that when corporate debtor is liquidated, the liquidator is required to make an account of liquidation showing how it has conducted and how the liquidator, how the corporate debtor's asset has been liquidated, in what manner basically the liquidation process has been conducted by the liquidator. It also requires the liquidator to provide the liquidation, if at all the liquidation cost exceeds by the estimated liquidation cost that was provided in the preliminary report. That as to on what reason and what was the reason that the estimated cost got increased. Then the liquidator is also required to submit an application along with the final report and the completion certificate to the adjudicating authority for closure of the process, where the corporate is sold as going concern, or for dissolution. This clarification was provided at a later part, given that given that pursuant to going concern sale, the liquidator is not required, the corporate debtor is not getting dissolved, but the corporate debtors get the liquidation process getting completed. Hence, this particular part was inserted. So if at all anyone sees any kind of development requirement in this particular regulation, may please say so. Okay, so I'm moving ahead with the next, which is preservation of records. This particular provision requires a timeline for which the records are required to be maintained. So what all records are required to be maintained, and for how long the records are required to be maintained, and in what manner the reports are required to be maintained are provided here. So basically there are two types of reports. One is the records that pertains to the corporate debtor, the books and records of the corporate debtor. And second is the liquidation proceeding documents, as to all the documents that liquidator has prepared or liquidator has come across with during the liquidation process. So how to preserve those documents, how long to preserve those documents, and in what manner those documents are required to be preserved. This is provided in this regulation.
Madam Barsha ji, this provision is also outdated provisions, because
Yes,
physical to maintain the or keep the physical record is very tedious job. And you know, today we are in the digital era. Everything is available in digital mode. We can have backup, 2-3 types of backup. We can have contingency plan, but these physical records is absolutely ridiculous. We cannot like.
So I'm telling you, sir, there may be a circumstances where physical records are being maintained during liquidation process itself, because the prelim report, the asset memorandum report in some of the cases are quite bulky. That it is not possible to maintain those in the electronic form. So what the liquidators are doing, they are initially maintaining those documents in a physical form and are making a part of the same, or recording a part of the same in electronic form subsequently.
So, after completion of liquidation process, after completion of dissolution, the liquidator should not supposed to keep the physical record. Liquidator do not have like they do not have this godown or storeroom. If they use this godown or storeroom of some offices, then somebody should pay the rent also. Who will pay the rent? Either IBBI should arrange. Only. See, Barsha ji, either IBBI should arrange their godown, that once the dissolution take place, the liquidator will deposit the all the records, physical record in the godown. That's it.
Sir, while I don't think so that IBBI is currently concerning of go down as such.
We are keeping records in separate place, and we are charging the rent from the in the liquidation cost. That
Yes,
is the
sir.
part of the liquidation cost.
Yes, sir. So what is
In that
usually
regulation
what
A, there
practically
is
is
some
being
error,
done,
actually.
sir?
Yes. In regulation itself, it has been mentioned.
Yes. So what is practically is being done, sir? The liquidator is maintaining the hard copy with the storage houses. They are entering into the contract with the storage houses to maintain the physical documents for at least 3 years in terms of the requirement of regulation. And for those 3 years, they are paying the storage cost in advance. And that cost is forming part of liquidation cost only.
And after 3 years?
After 3 years, either in archive form or they are giving the documents.
He can
We
burn
are
the...
to otherwise as well are maintaining the documents, but what others and in what manner others are recording the documents, that I would also like to hear from other professionals.
We have made the agreement for 8 years.
8 years, and what about after the 8 years, sir?
After 8 years, it will be destroyed.
Destroyed.
No responsibility, yes. No responsibility of liquidator.
Yes, yes.
It
So
cannot
either...
be.
Can you go back to that A, regulation A? It is, that is.
Sorry, sir.
Can you go back in that term of preservation of records? A, B, ka hai?
Yes, sir.
Can you come to that? Actually, once it says 8 years and then it says 3 years, there is a little confusion, I think so.
It says that liquidator shall preserve copy of all the records which give complete account of the liquidation process. Then the next says that without prejudice to the generality of the provision of subregulation 1, the liquidator shall preserve copy of records relating to or forming the basis of these documents. And then here it says that the liquidator shall preserve electronic copy of all the records for a minimum period of 8 years and physical copy for a period of 3 years.
No. In that electronic, both physical and electronic, both it has come.
That is in CIRP. In CIRP.
No. It is provided that liquidator shall preserve electronic copy of all the records.
Then again physical.
Physical and electronic.
Physical for 3 years.
Electronic copy, then it says physical and electronic.
Nitesh, please mute yourself.
That's my doubt. That is an error, right? It seems.
It's correctly pointed out, sir. So this is a typographical error. This should be electronic form only. That electronic document should be maintained for a minimum period of 8 years.
And bracket should not be there.
Yeah, there is no need for bracket.
Yeah, bracket is redundant.
Yes.
Yeah, bracket is redundant.
Well pointed out.
This regulation also says that when the corporate debtor has been sold as a going concern, in that case, the general records of the corporate debtor shall be handed over to the successful buyer. Of course, this is for the need and the subsequent requirement of the successful buyer, that it requires that all the documents that belongs to the corporate debtor, that pertains to the corporate debtor, may be handed over to the successful buyer only.
Then liquidator will
How long he should keep?
Sorry, sir?
Liquidator will not be responsible.
That will be completely discretion of the successful buyer, because once you hand over the documents to the successful buyer, it is completely on his discretion. Correct. Now, liquidator is not bound to maintain the documents which are with the successful buyer. So the foundation is only with respect to the documents which are maintained by the liquidator or which are in the records of the liquidator, and not the documents which you have already transferred to the successful buyer.
Is there any provisions for exiting? Can liquidator quit in between liquidation process?
Sorry, sir?
Can liquidator quit as a liquidator?
So it is not provided so far in the liquidation regulation. The option of quitting the liquidation process is not provided. If
so
it
there
was,
should be
this
some
provision
provision
will be there, sir.
So kindly suggest to IBBI in this through this webinar to incorporate such provisions.
Because this may also raise certain eyebrows, sir, in that regard, that if, say, suppose there are realization, there are distribution, and the particular liquidator has taken his fee on the realization and distribution and decides to quit because the connected
there should be
applications are
certain
pending.
criteria. No. After getting the benefit, that is not reasonable. There should be some criteria.
Yes, with
in
proper
certain
criteria
cases,
as to at what time the particular liquidator may quit. Now, next is corporate liquidation account. This says that the board shall operate and maintain an account which is called corporate liquidation account. Here the board is IBBI. It says that provided that until the corporate liquidation account is opened as part of the public accounts in India, the board shall open a separate bank account with a scheduled bank. So I'm not sure if at all this account has been opened, because we have not faced any such requirements of depositing any money in the corporate liquidation account. However, if any professional has faced this or has deposited money, or if had faced any issue with respect to this depositing account in the corporate liquidation account, may please share their experience. Or if they think that any particular changes is required in this particular provision. Okay, so this is completely on board, that it requires the board to get the accounts audited as well. Then audit report along with the statement is required to be placed before the governing body. So this is completely on the requirement that are required to be pursued by the board. So nothing to do with the liquidator per se. Coming to the model timeline. So this model timeline is based on the regulations that we have discussed above, and I'm not repeating this part. Coming to schedule 1 part, which is the manner in which the auction or the sale process should be concluded. This says that where an asset is to be sold through auction, a liquidator shall do so in the manner, here the in the manner is just a bit typographical error, in the manner specified herein. Says that subject to the provision of regulation 2B, liquidator shall issue a public notice of auction for the sale under regulation 32 within 45 days from the liquidation commencement date, until the consultation committee advises to extend the timeline. So it says that public notice for the issuance for the notice of auction is to be issued within this timeline of 45 days from the date of liquidation commencement. However, we have also seen that asset memorandum part, it says that asset memorandum is to be prepared either in 30 days or 75 days. So are we saying that until unless even if the asset memorandum is not in place, one can move ahead with inviting public notice for this auction? And the second part is that the liquidator shall issue public notice for the next auction in case of failure of auction within 15 days from the last failed auction, unless the consultation committee advises to deviate the same. So if the liquidation process, if the auction fails within next 15 days, will it be possible to conduct the next auction? I think the very reason for which the auction failed has to be addressed to by the liquidator, and 15 days time is not sufficient to conduct the next auction. So these timeline, I don't think so how practical these are to implement. First, the 45 days timeline for issuing of public notice is not going in line with the requirement of asset memorandum, not going in line with the requirement of liquidation regulation itself. As on one part, it says that asset memorandum is to be prepared within 75 days or 30 days as the case may be.
What about the disputed assets? What about the disputed assets? Suppose land belongs to this director, suspended director, and building belongs to CD, but director is claiming that yes, building is also belongs to them. Now, in case of such dispute, what should a liquidator do? Like he can sell this asset through auction. He can put the name of the building in the auction.
So those clarifications should also be there. While today liquidators are using their own discretion based on the best mode that they think is available, that some liquidators are moving ahead with a disclaimer. Some liquidator are moving ahead with, prior to moving ahead with the sale notice, they are entering into agreement with the landowner or the adjacent asset owner to move ahead with the sale. Or some liquidators are moving ahead with the seeking permission of NCLT. Given a lack of clarity here, currently the liquidators are using their own discretion. However, the clarity
you mean to say till the pendency of the application before NCLT, this 45 days, the clock of 45 days will not start?
Absolutely, sir. Currently, that is the thing only, because it says that liquidator shall issue the public notice for auction. So if you do not have the permission to auction, or if you do not know what to auction, how will you auction? So at least you have to have the hold of the particular asset that you are intending to move ahead with conducting the auction. If you are thinking that you will move ahead with auction of a building, so you have to have control on that building to move ahead with the auction. Until unless you have the control on that building, how can you move ahead with the auction? How can you make the public notice? Because in any notice, you are required to provide all the connected terms and conditions of the sale. So you have to have all the details with the sale to move ahead with the auction notice.
Okay, thank you.
Madam,
Next.
I have a point here. This is Vikram
Yes.
Bhatnagar. The 45 days mentioned here in sub-regulation 1A actually should mean, but within 45 days from the time that the liquidation estate is formed. Because even the
Right.
liquidation estate may take time to get formed. Charges may not be seeded by
Absolutely,
the
absolutely. So that
SCC
is
and
the
whoever.
point that I have also pointed out, that
Yeah.
until unless you have the asset in hand, or until unless you know as to what to auction, this 45 days timeline will not be of help for the
Yeah.
liquidator. So moving ahead with the next part, which is notwithstanding anything contained in schedule, the liquidator shall complete an auction process within 35 days from the issue of public notice auction. So this says that the timeline for inviting EMD, from the due diligence of the asset, and then auction process like pre-auction requirement, etc., has to be completed within the period of this 35 days only. The next part is the liquidator shall provide at least 14 days from the issue of public notice for submission of eligibility documents by the prospective bidder. So here I believe that the entire timeline for the auction is being reduced so as to achieve this particular notion of time-bound manner. However, the time restricting the timeline will not help the liquidator, will not help the liquidation process to get completed, because here all the timelines which are provided, particularly this particular timeline which deals with the issuance of notice, is not going in line with the requirement of the liquidation regulation itself. Now, next part, which is about liquidator shall provide to qualified bidder at least 7 days for inspection of due diligence of assets under liquidation from the declaration of qualified bidder. So if we see the timeline, it says that first the liquidator is required to issue the notice. Then after issuance of the notice, the liquidator is required to check the eligibility. After checking the eligibility, the liquidator is required to give the timeline to the prospective buyer to conduct the due diligence. And after the due diligence, the liquidator is required to move ahead with the auction process. It also says that prospective bidder of the auction process shall deposit the earnest money deposit at least up to 2 days before the date of auction. So very short timeline has been given to the prospective bidder as well to move ahead with the auction process. The liquidator shall prepare marketing strategy, etc. So here one concern, in order to invite the serious bidders, the requirement of certain non-refundable fee should be there, because otherwise it will invite the random participants for the auction, and the auctioneer, the prospective buyers will randomly participate and will later on deny to move ahead with the not to move ahead with the sale process. So just to invite the seriousness in the sale process, there may be certain non-refundable fees which were earlier there that should also be here. That is what my perspective is. However, other professionals may give their views on this part as well. And the regulation requires the liquidator to prepare a marketing strategy. However, it has been seen that the terms and conditions of sale is still very much restrictive and is completely dependent upon the adjudicating authority to give a stamp upon, and not completely in the hand of liquidator, because there are several applications which are pending before the adjudicating authority, which are questioning on the right of the liquidator to prepare the terms and conditions of sale. So here this subsequent regulation which requires the liquidator to prepare the terms and conditions of sale should also give the liquidator the discretion to decide as to what the terms and conditions of sale should be. This also includes the reserve price, the earnest money deposit, as well as pre-bid qualification. it says that liquidator shall not require payment of any non-refundable fee or fee for participation in auction under liquidation process. But this specifically restricts the liquidator to take any non-refundable fee. However, I personally believe that even a small
Yes,
amount
this
of
will
fee, if
this
will
will
be there,
prolong
that
this
will
will
invite
prolong the
seriousness.
liquidation process. That's why I was telling this will prolong the liquidation process. That's why I am asking is there any provisions of quitting the position of liquidator? We cannot marry with the CD for an indefinite period. ये जन्म जन्म का साथ नहीं है हमारा CD में.
वो तो अभी फिलहाल वही रहा है सर, जब तक चल रहा है मैटर तब तक तो लिक्विडेटर भी सारे अटके ही हैं इस प्रोसेस के साथ में.
Correct.
So the idea is only to invite a serious bidder in the auction process. So
Very
even a
true.
minimal amount of non-refundable fee should be there so as
Very
to
true.
invite seriousness in the liquidation process, and the auction process should not be a random process for any of the persons to for doing a window shopping or just coming for the sake of participation randomly.
Fully agree. Fully agree.
Is there a refundable fee provision under the company liquidation under the Companies Act?
Sorry, sir.
Is there a refundable fee for liquidation under the Companies Act?
So section 271 is there. However, I don't think so that this non-refundable fee requirement is there even in Companies Act as well.
So if that is so, then we cannot prescribe, because for IBC alone, then it becomes very restrictive. See, typically even in SARFAESI also,
Sir, because here we are not asking about a huge amount of non-refundable fee. Non-refundable fee can be a minimal fee as well. Say 5,000.
What I'm saying is what is also applicable to other laws. See, similar is there in Companies Act, similar is there in SARFAESI Act. So I am an experienced person in SARFAESI. In SARFAESI also, EMI is earnest money is there, but there is no non-refundable. It's not like that. We cannot put a restrictive clause which is not there in other acts.
Sir, but other laws are not time bound. Here, the liquidation process is time bound. You are required to complete a process within a given timeline.
Agree. That is why we are prescribing 10%. 10% the EMD is there.
This is earnest money deposit, sir.
Yeah,
this is
exactly.
not that random that non-refundable fee. Why I'm saying so? Because before moving ahead with this process, the prospective buyer will ask you some 1,000 questions about the assets, and the particular buyer may not be serious even. He may ask 1,000 process and later on will take the step back. So if you are putting effort to answer to the particular person or particular buyer, prospective buyer, then at least you have to have that particular confidence that the person is serious about purchasing the asset and is not just randomly asking questions to you, because that is also taking your time to respond to.
No, that's why the rules provided you can appoint a professional. You entrust those matters to the professional.
No, sir. When it comes to the queries pertaining to corporate data, a professional cannot answer those queries.
No, I am saying that
only required to answer the queries.
The queries concerning the property that can be given to the professional.
So when it comes to liquidation process, whatever the assets pertains to the corporate data, and if a prospective buyer has concerns with respect to that particular assets or of that forming part of liquidation estate, then liquidator is required to clarify the concerns and not a particular professional on the concerns relating to that.
Agree, but my query was only specifically relating to the property, because my worry is I do not favor putting a non-refundable because it is not there in any other act.
I completely agree with you, sir, that this thing is not there, but given that time-bound process of liquidation process, just to invite the seriousness, I thought that should be there. However, of course, this will go with the practicality and the requirement that IBBI thinks should be proper to insert in the provisions. Now, coming to next part, which is reserve price, it says that reserve price shall be the value of assets arrived in accordance with the regulation 35. We have already discussed in regulation 35 that in regulation 35, just one line should be inserted that this reserve price is the minimum price and not the maximum price or any other price, just that this reserve price is the minimum price below which the asset should not be sold. Now coming to the next, which is where an auction fails at a reserve price, the liquidator may reduce the reserve price by 25%. So whether this 25% can be reduced all at once, or the liquidator is required to reduce first 5% and subsequently 10%. Here the subsequent regulation says that where an auction fails at a reduced price under 4A, the reserve price in subsequent auction may be further reduced by not more than 10% at a time. So it says that when the first says that when an auction fails at a reserve price, liquidator may reduce the reserve price by up to 25% on such value to conduct the subsequent auction. And the later part says when auction fails at a reduced price as well, then the subsequent reduction should not be more than 10% at a time. So here I think some blocks should be there that not exactly, say suppose first auction failed. So at 100 rupees. So I'm required to sell the, or I can reduce the sell price directly to 25%. There should be some stages of reduction of price, and that should not be direct reduction of the open-ended discretion of reducing the price to 25% may not be there, or may be restricted to, so as to give some sort of clarification here to the liquidator as to how much price should be reduced at a
Yeah,
time.
I fully agree, because that will lead to some collision otherwise.
Now coming to the next part, which is liquidation, the liquidator shall issue public notice of an auction in the manner specified in 12.3. Then provided that liquidator may apply to adjudicating authority to dispense with the requirement of public notice, keeping in view the value of the assets intended to be sold by auction, which is in general requirement. Then this next says the liquidator shall provide all the necessary assistance as necessary for conduct of due diligence by the interested buyer. Then
Madam, excuse me.
Yes, sir.
Regulation 4A, can you scroll up to that? 4A.
4A.
Reduction,
Yes.
yeah, reduction by 25%.
Yes, sir. Yes, sir.
What I'd like to add here is that the justification for reduction by whatever percentage should
Yes.
have to be provided by the liquidator.
Absolutely.
Like it should depend on the onerousness of the property or certain conditions like tax liability on it, or some lien applied by some GST authority or whatever. There are so many possibilities. So that justification must be put on record.
Because there may be circumstances where, just to give a comfort to a particular buyer, the liquidator is reducing the price by 25% all
So
of
it should not be that way.
So proper justification should be there. I completely agree with you on this part.
Okay. Thank you.
Then coming to the next part, that says that from a particular date to be notified through circular by the board, liquidator shall sell the assets only through an electronic auction platform impaneled by the board. I'm not sure if at all this particular impanelment has already been done. However, if this is being done, so I think that this will be favorable for the liquidator, because currently the liquidators are moving ahead with the other e-auction service providers to move ahead with the auction process. So it will be alignment of the process if IBBI is particularly providing any impanelment of a platform like that. Next says, if the liquidator is of the opinion that a physical auction is likely to maximize the realized value, realization from sale of assets, and is in the best interest of the creditor, he may sell the assets through public auction after obtaining the permission of adjudicating authority. This is again we can say that this is again something which is not kept at the discretion of the liquidator, but liquidator is required to take permission of the adjudicating authority if the liquidator thinks that a physical auction is likely to maximize the process, which I don't think so that currently is happening in any of the liquidation process. So far, all the liquidation process or the auction process are being conducted through online mode only, but there may be certain cases where physical auctions have happened. I'm not aware of those process. Auction process shall be transparent. Highest bidder at a given point shall be visible to other bidders as well. So these things are, I think, are requirement with are in line with the normal requirement of auction only. Then it says that if a liquidator is of the opinion where auction that an auction where bid amount are not visible is likely to maximize the realization value, then he may also do so with the permission of adjudicating authority. That none of the bidders will be able to see as to what the other bidder has bidded, and there will be a random bidding process. Whether a particular amount of the increased value should be provided, that if you are putting a bid higher to that of the previous bid, then at least this bid should be there. and you are not disclosing as to which particular bidder has bidded what price for the assets. Then next is if required, the liquidator may conduct multiple rounds of auction to maximize the realization from the sale of assets. That is again on the discretion of liquidator only. And there is one insertion which says that the liquidator rejects the highest bid in an auction process. He shall intimate the reason for such rejection of the highest bidder and mention it in the next progress report. So this rejection has to be reported, and I think that this rejection, this should be discussed in the stakeholder consultation committee as well as to why and on what ground a particular highest bid has been rejected by the liquidator. Next is about on the close of the auction, the highest bidder shall be invited to provide balance sale consideration within 90 days of the date of demand, provided that payment after 90 days shall attract at the rate of at interest at the rate of 12%. 12% per annum should be there. The provided that the sale shall be cancelled if payment is not made within that period of 90 days. So first it says that payment has to be made within 90 days. However, if payment is made after 30 days, then 12% interest will be charged. And if the particular acquirer fails to make payment within 90 days, then the sale shall be deemed as cancelled. Then subsequent action part, that as to what timeline the liquidator can proceed ahead with subsequent auction, or should the liquidator give the opportunity to the next highest bidder to move ahead with the auction process. These clarities are required. And the most important clarity which is required here is the forfeiture part. That just to avoid this random participation in the auction process, there are several cases before the NCLT wherein the liquidator has forfeited the amount paid by the liquidator, amount paid by the successful bidder, where the successful bidder has made part payment towards a sale consideration, however, failed to make payment towards a full sale consideration. In that circumstances, in terms of the auction document, in terms of the contracts entered into between the liquidator and the successful bidder, the liquidator has forfeited the amount. However, it has seen that the successful bidder has questioned that discretion of the liquidator as to on what basis the liquidator has forfeited the amount. The liquidator so far does not seem to have the right to forfeit the amount. So this clarity on forfeiture should also be there in the regulation itself, so as to avoid any concerns in this particular regard. Coming to the payment of full amount, it says that on payment of full amount, the sale shall stand completed and the liquidator shall execute sale certificate or sale deed to transfer the assets, and the assets shall be delivered to him in the manner as specified in the terms of sale. The next part is about private sale, that when private sale happens with the permission of adjudicating authority or with the discretion of liquidator or with the consultation of a stakeholder consultation committee, how that process should be taken forward. It says that where an asset is sold on private sale basis, liquidator shall conduct the sale in the manner as specified in this particular part, clause 2 of schedule 1. Liquidator shall prepare a strategy or approach of the interested buyer to sell the asset on private sale basis. Private sale may be conducted through directly liaising with the potential buyer or through agents, through retail shop or through any other means that is likely to maximize the value of asset. Then the sale
You
shall
mean to
stand.
say the both options are available? This
Both the
private
options.
sales and
Yes, sir. Yes, sir. So as we discussed
Therefore, to save the time, even you can resort to private sale with the consent of the SCCI also.
Yes, yes. So you may decide as to if you think that you will go ahead with the private sale, then you are required to take permission of the adjudicating authority, and then you can move ahead with the private sale. There are also certain restrictions.
It is not written here with the
no, adjudicating authority is not required. I think
I think that
committee.
Private sale part, selling of private sale part was covered earlier as well. was here that liquidator may sell the assets of the corporator by means of private sale in the manner specified in Schedule 1 when the asset is of this is nature with the prior permission of adjudicating authority has been obtained for such sale. So this part was there in Regulation 33 that requires prior permission of adjudicating authority, where we discussed that discretion should be of liquidator and there should not be a requirement that liquidator has to go to adjudicating authority for conducting such private sale. So this Regulation 33 is linked with Schedule 1 Part 2 that says about private sale. So as of now, for private sale, the liquidator is required to take permission of adjudicating authority. I hope I am clear in this part.
Yes.
So I'm quickly moving to the with this requirement of private sale. Yes. So this says that liquidator is required to prepare the strategy. Then liquidator may conduct the private sale either directly by liaising with the potential buyer or through the agents of retail shop or any other means that he thinks that is likely to maximize the realization from the sales. Then it also says that sale shall stand completed in accordance with the terms of sale. Thereafter, the asset shall be delivered to the purchaser on receipt of the full amount. So here we complete the liquidation regulations and the requirement, because in subsequent part, only the format to be followed are provided.
It's almost 2.5 hours.
Yes, sir.
It's almost 2.5 hours now. Okay.
So I think that we are done with this liquidation regulations.
Yeah, okay, good.
Barsha, have you come across any case in which suspended management has agreed to settle all claims of the creditors during liquidation and wish to get back his company? Have you come across any such case? Or
I have not seen any particular cases. Others may see their may
There
share
have been
their
cases,
experience.
ma'am, there have been cases where 12A has been used in liquidation.
So 12A during liquidation you are referring to?
Yes, yes.
Okay.
There are 6 cases in all on 12A during liquidation, where the manager has settled the matter with the creditors and actually proceeded to move with the company.
Okay, so
that particular requirement
given the permission. You mean to say, Sarmaji, you mean to say AA has given the permission for withdrawing?
Yes, 12A is applicable in liquidation too.
Okay. In which NCLT?
In many NCLTs. You can probably do a Google and you'll get those cases and a number of them. Ma'am, my point, my query was regarding voluntary liquidation.
Yes, sir. Yes, sir.
I have 2 points in voluntary liquidation. One, the new regulation says that we should endeavor to complete it in 90 days. In the event of a voluntary liquidation, is the onus of surrendering the EPFO, GST, etc. ours? Second question is, in the event that the only thing that's left is basically an income tax refund, can the stakeholders or the shareholders be given the money prior to that or not?
So voluntary liquidation is about solvent liquidation, where I have sufficient money to make payments to all the stakeholders. Once I am done with the payment to outsiders, the creditors, then whatever money I have, I will distribute that money to the contributories only. So either I can wait for the income tax refund to come and then I distribute that amount only to the contributories, or I can simply enter into a contract or arrangement with the contributories that see this amount will come, and as and when the amount will come, the amount will be distributed amongst the contributory in the manner of in the proportion of their contribution. So if that is agreeable to the contributories, I can simply move ahead with the conclusion of the process.
I appreciate your point, but my supplementary question to this is that though there is a refund claim in the return filed by the corporate debtor per se, which is the company, how does the RP take the entire onus upon himself to see whether that refund will come and whether there will not be a demand in the contra vis-a-vis the income tax department? So how does, for example, there's a 1 crore refund lying there. I would trust that there's a 1 crore refund. So even if there's a reduction, it will be probably 70 lakhs. And there's a 5 crore lying in the balance, and the shareholders tell me distribute that amount, and the refund amount can be distributed later, as you mentioned. And I agree with you. I'm also of the same view. But at the end of the day, if, for example, that 1 crore refund now gets actually converted by the department because of disallowances for whatever reasons, we are all professionals, we know there are a number of reasons that could happen, and it is then a demand of 20 lakhs. Then what do I do?
So in that case, the liquidation itself is not a voluntary liquidation. It will turn into compulsory liquidation. Because if, say, suppose the fund is not sufficient to make payment to the income tax demand holder, in that case, the company is not even in the state of going forward or go ahead with the voluntary liquidation.
No. So my point is that I'm going through a Section 59 process. I have actually paid the shareholders 5 crores that is lying in the bank in the hope that they will get a refund of 1 crore. Now, I can't close the account also simply because of the fact that the refund is actually linked to that account. Now, if instead of the refund coming in, I finally receive a demand of 20 lakhs, right? Now, you're right. If it is the Companies Act structure, they are required as a shareholder to be a contributory still, and they're required, and we take an affidavit also at the end of the voluntary liquidation to actually say that as a contributor, you will still actually pay anything that comes by later. But the fact is that if this happens, is the onus not on the voluntary liquidator? Should we wait? If we have to wait, then the regulation of that 90-day, which is the word may, though of course the word is may, should I read it as shall or should I read it as may? What do I do?
So please allow me to clarify on this part.
Yeah.
This voluntary liquidation process begins with a declaration of solvency by the directors of the company. So majority of directors of the company has given this declaration per se that the company is solvent enough to make payments towards all its dues. Next, when it comes to distribution part, say the only asset which is there is the income tax refund, which the company may or may not receive. However, the liquidator cannot be expected to wait for the time till the income tax refund is being credited back to the liquidation account. Max to max, a liquidator can wait for a year. However, it cannot be such that within 1 year, the company will receive the income tax refund. So ultimately, whatever will be distributed, if the situation is such that the only stakeholder in the list of stakeholder is contributories of the company only, in that case, liquidator may enter into agreement with the contributories that if at all there will be any refund, that refund can be distributed among the contributories in proportion to their contribution. However, if at all there will be no refund, instead there will be a payment, then the payment has to be made by the contributories only. So having entered with this agreement, the liquidator can move ahead with the dissolution of the company. Of course, at the time of dissolution application, the facts regarding this particular distribution of unrealizable or not realizable asset can be given to the NCLT or the adjudicating authority for their record as well.
But one of the criteria is to close the bank account. Now, the bank account
again, sir, when it comes to bank account, if you notice, there is the requirement is to open a separate account with the name voluntary liquidation account. So what happens is the moment you open this special account, they change the status of account from normal account to liquidation account. So for that, you are also required to enter into an agreement with the bank, wherein bank is required to change the status of the account from special account to normal account. That happens and bank does that. They change the status of the account and you say that authorized signatories are also being changed. So you will not be the authorized signatory, and the agreement will say that you are required to maintain this account for this particular year only, and this account will be used only for receiving the payment from income tax department and for no other purpose. So you are holding this account, this liquidation account, only for this particular purpose. And the facts regarding maintaining this account is also required to be given to the adjudicating authority. The similar situation we have also faced, and we have made an application with the NCLT on these grounds only.
And you've gotten an approval on that?
No, sir, the application, the dissolution application is just being filed, so I'm just sharing that facts with you.
Thank you. Thank you. You're very clear. Thank you very much.
Thank you, sir. So, Nitika ma'am, I believe that we can conclude for the day, given that we are done with the liquidation regulation. Unfortunately, we could not touch upon the voluntary liquidation part, but I think that for today's session, we are done with the liquidation part at least.
Ma'am, can you share your coordinates, please?
Yes, sir. I think Nitika ma'am will only share with you.
All right. Thank you.
Thank you, sir.
So
Thank you,
thank you
everyone.
for the session, and thank you to all the participants.
Thank you.
Thank you.
Thank you.
Thank you. Very valuable.
Thank you.
Thank you. Good effort by Barsha.
Thank you.